What can you tell us?
Well, an appeal will definitely be taken. The federal sentencing guidelines are extremely difficult. We knew that going in. Our client knew that this was a very risky case to go to trial, to be acquitted of.
Excuse me. Yeah, well, you gotta close the door, buddy. Okay, thank you.
Sorry, we're on live TV. Sorry.
To be acquitted of 27 counts.
Hey, folks, how about you move? Move it. Come on. You're blocking a fire right here. Thank you.
We'll go down the steps.
Yeah, why don't we just move down the steps?
You've got a crowd here.
On your way down, can you tell us your reaction to 28 years?
Well,
Take it down.
I can tell you that the 28 years is not something that we expected in light of the fact that an initial plea was negotiated between the government and us for 84 months, and the government and us thought that 84 months was clearly fair to the circumstances. I think in reality, I think the government was probably even shocked with the 336 months, whatever it is. And, but as lawyers, we have to continue to argue on behalf of our client. The appeal will be filed within 14 days, and matters will be addressed before the Third Circuit Court of Appeals.
Where's Mark going tonight?
Don't know. Mark's attitude was that he wanted to surrender himself today. He did not want to ask for a reporting date. That was the position he took, even before the sentence was announced. And we agreed to follow his wishes in that regard.
What's his outlook?
Mark is a very resilient individual. He took everything in stride. He had requested that no letters be submitted to the judge on his behalf because he did not want any friends to be subjected to any type of public ridicule or scorn. That was his choice. He did not want any members of his family to speak in court. That was his choice. And so it's a very tough decision.
Al, how do you prepare a client for a possible life sentence? What do you tell them before you go into today?
You really, it's a really difficult thing to do. We knew going back before this case went to trial that the sentencing guidelines were so severe that if he was convicted on just one count, he could be looking at a long time in jail. So we were all aware of that. And but Mark's attitude all along was that he never accepted a bribe or kickback in exchange for sending a child to a detention facility, and he maintains that to this day. It was his decision to go to trial.
Do you think not apologizing to the kids, despite whatever the Pennsylvania State Judicial report was, hurt him in his last final moments in court today?
No, I don't think that made any difference.
He didn't apologize. He did not apologize for the things he did to my grandson.
Now, can you tell us what you thought about Gordon Zubrod getting up and really hammering away after Ciavarella made his appeal to the judge?
Well, Gordon is a very effective prosecutor. I have a great deal of respect for him. I think he fulfilled his obligation that he was required to do. And I'm not here to criticize prosecutors. I've never done that in the past, and I don't intend to do that today. This was a hard-fought case. I think the prosecution was surprised there was 27 acquittals. But the federal guidelines are very, very tough to get around in sentencing.
Now, Mark spent most of his time today talking about stigma. It's pretty bad. He said, it's the last thing he does. He wants people to know he didn't sell it's for cash. Why? Is that's just his mantra now? That's what he wants to get across to people? But
that's something that he really wanted to get across from day one. That was the driving force behind him going to trial. And that's what really caused him to go to trial.
My son paid into it. My daughter paid into it. So did the
Do
county.
you think the fact that he got up and again denied, gets asked and again denied the fact that the allegations that he had violated human rights, do you think that that negatively impacted the sentence?
No, I really don't think so. I think Judge Kozik, when he came out on the bench, obviously, wanted to hear the elocution that Mark gave and wanted to hear comments from us, but I think probably Judge Kozik had a sentence in mind at that point. And I don't think Mark's remarks in any way, increase the sentence if that's what you're asking.
Al, at one point, Judge Kozik made reference to the friendships between Billy Rizzo and Mark Ciavarella and you, Mark Ciavarella, and you felt the need to distance yourself. Why did you do that?
Because it was really inaccurate. I only ever had one civil case before Mark. I knew of him. He went to school with some cousins of mine. But as you know, Steve, I grew up in Baltimore, and I came back here, a couple years after law school. So I really didn't know Mark that well, and I never socialized with him or anything like that. And that's why. It really had nothing beyond that. Billy came in as a friend, and Billy Rizzo, the person who brought me into the case because of my knowledge in dealing, really with judicial misconduct. That was my background when I was brought in.
What do you think the key issues on appeal going into?
Well, I think there's going to be seriously the recusal issue of the judge. I think you're going to see serious issues surrounding Gordon Zubrod's admissions with regards to the miracle payment.
The quid pro quo.
Yes, that was a finder's fee and not a quid pro quo. I think that's going to be a serious issue. I think the judge keeping out information relating to Robert Powell in terms of money he took out of PA child care. We're not able to attack Powell's credibility in that regard. I think that's going to be a significant issue. The statute of limitations is going to be a significant issue. So we have about 5 issues that are meritorious. They're not frivolous issues. And the appellate courts are going to have to deal with it.
Speaking of the recusal issue, did the letters that Judge Kozik
I wonder if you would feel the same if it was one of your children or one of your relatives. Would you be standing here talking about that now? Apparently, you don't want to question or answer anything like
He's
that.
on the juvenile board, which makes him double jeopardy. And I'm not a lawyer.
The letter to you.
Yeah, we did move for recusal in chambers. We referenced the fact that he had written letters to some people, expressed his opinion in those letters, and we again renewed our recusal motion. He denied the motion.
And is that was on the record? So that can be in
That's on the record.
That's the 4th time you asked me
I lost track.
And you also asked for the mistrial. That's another.
Yes.
Hey Al, forgive me, I came in a little late to this wrong here, but I was told you view this as a harsh sentence.
Well, I think the sentence of 28 years. I think surprised us. There's no question about it. The federal guidelines are very difficult to deal with. You have a guy who's really acquitted of 27 counts, found responsible for receiving 1 payment. You get 28 years. I got news for you. I've represented people who committed third-degree murder, and they've gotten 7, 8 years. So this is quite a shock.
Which did call for a life.
Yeah, the guideline was life, and that's what they called for.
May I ask, is this effectively a life sentence? In the light of the fact that he's 61 years old?
61 years old. What do you think? He'll get so much time off for behavior. 28 years, maybe not 5 off for behavior. Now you're down to around 23.
Any idea what kind of facility?
Don't know. I don't know where the Bureau of Prisons will send him. Obviously, security for him is always will be an issue, and so the Bureau of Prisons will make that decision.
You know immediately where he's going?
No.
Now, we were asked to leave the court just for crowd control.
No, he was not. He was not handcuffed. He was taken into another room. Some of his personal belongings was given back to the family, and that was it.
How much of an impact do you think it
Well, I'm really not here to speculate. You know, the judge made his ruling. We'll deal with it on appeal, and that's it. I'm not going to start speculating what's in the judge's mind.
What was your take on his decision to hit so hard at statement that he had not taken money from kids? It seemed to overwhelm any kind of emotional remorse in terms of the tenor.
That's really what drove this whole case. From our perspective, day one, he was adamant that he did not take money in exchange for sending kids to facilities. It's this kids for cash branding that ultimately caused him to go to trouble. If it wasn't for that, this thing probably would have went out a long time.
What do you think about the judge talking about the Supreme Court and the vacating of all the sentences?
Well, we obviously, take some issue with that. I mean, there's obviously a serious problem from our perspective of the court bringing into, taking into account proceedings which really had nothing to do with PHL care or Western PHL. To have gotten into an argument with the court over the entire interbranch commission report. I mean, we'd be here a week, 2 weeks. I can tell you, this much. Mark Ciavarella's courtroom and the fact that there was no colloquies, that was pretty much standard procedure back in those days, no matter what judge you had on the trial. It wasn't limited to Mark Ciavarella.
Not different than New Jersey.
So, things were looked at very differently back then. You got to remember, up until October of 2005, Pennsylvania didn't even have any rules of procedure for juvenile court. It didn't exist.
Are you saying that 6 months in jail is standard for fighting in your classroom? That's standard?
I don't
Or
know.
is everybody lying? All the courts are lying. Everybody's lying except
Juveniles don't get no reputation. They're not people, huh? No attorney, no attorney.
They have no right.
Violating juveniles without no reputation.
Ciavarella said that he never violated any juveniles' rights. I remember talking to Judge Ciavarella in May 2008. He did admit that he never read the colloquy at points, and he never informed juveniles of their rights to an attorney. Is that sort of a nuanced thing, or how does he come about saying he never violated rights when he has said that procedures were a little abridged?
Yeah,
Is it a semantic thing, or?
Going back to that time, I think the procedures they had in place, I think Mark and the other judges probably felt were correct when you had probation, giving the letter to the parents, advising the parents, here's your right to counsel, you can obtain counsel, so forth and so on. And by the time the kid got into court, I think there was a general attitude that the kids were familiar with the rights.
He was 11. 11.
Obviously, things are not done that way today. I tend to think that if you went around during that period to other courtrooms in the state, you might find similar types of procedures that went on during that period. And that's really all I can tell you.
How you may have